Every criminal defendant in Massachusetts has the right to choose between a jury trial or a bench trial. Now, a bench trial is when the judge sits as the finder of fact. So the judge sits in place of the jury. Now, there's obvious advantages and disadvantages to having a bench trial. Probably the biggest advantage is the speed at which you'll get the trial. So in most cases, if the criminal defendant is not detained, he's not in jail while the proceedings are going on, and the defendant is released on his own recognizance or he's paid bail, it will take months, several months, 3-4 months or more, for the defendant to get his jury trial in some cases. Now, a bench trial can very often be scheduled within a couple of months, maybe a month or two. So that is a key advantage. But when you decide to do this, you need to be aware of the rights you're giving up. You're going to have to go on record before the judge and freely and voluntarily waive your right. And one thing you really need to keep in mind is the judge that you anticipate sitting at the bench trial. Obviously, you would want a fair, somewhat lenient judge to be the judge if you have a bench trial. And you also have to keep in mind that the judge that you are anticipating, unless he's taken jurisdiction over the case, it may not be the judge that you get on the day of the bench trial. Right? So I've written a blog post on this, and I'll put it in the description below.